It's my pleasure to introduce today's speaker, David Satola. Mr. Satola is lead counsel for the World Bank. For those of you who are unfamiliar with the World Bank, it's not a bank in the ordinary sense of a bank. You can't go to it and get a loan to buy your house or to buy your car or to pay your law school tuition. Instead, it's a source of financial and technical assistance to developing countries all over the world. The bank's broad aim is to reduce poverty and to support the development of these developing countries. They engage in a wide variety of activities, including micro loans, providing support for the education of girls, and improving health care in developing countries. They have over 100 offices worldwide and over 9,000 employees. And it does a world of good all over the world. And this man is lead counsel. What a great job. I think if there's a Q&A afterwards, first question somebody's likely to ask is, how can I get your job? Mr. Satola received his BA and his MA from the Johns Hopkins University. He received his law degree from the University of Wisconsin in that beautiful small town of Madison. And he has also studied at the London School of Economics and at the Hague Academy of International Law. Before joining the bank, he was a member of a private law firm here in the United States and a member of a law firm in Brussels. He was also legal advisor to a human rights NGO. And perhaps most important to us, Mr. Satola is active in the cyber law section of the American Bar Association. And that's selfishly important to us because Professor Ed Morse is also a member of that section of the ABA. And through their work on this ABA section, they've become friends. And we've used that connection to get him here today to speak to us on the regulation of online freedom. So most of you have heard me talk enough over your lives, so I'm going to sit down and turn it over to David Satola.
Well, thank you all. It's a pleasure to be here in Omaha. In all of my world travels, I have to say this is the first time I've been to Nebraska. So thank you, Ed, for inviting me here. Thank you, Dean Culhaney and the whole law school for inviting me out here. Thank you to the Koley Foundation and law firm for sponsoring this event. I think it's a great opportunity. I'm humbled to be here to speak to you today when I look at the roster of people who preceded me. I hope that you find it interesting, and I hope not to disappoint you. So in addition to the kind remarks that you just heard, let me take just a minute to tell you what I do at the World Bank and why I'm standing here talking to you about this stuff today. I'm responsible for the telecommunications and ICT, information and communications technology work that the bank does globally, which is investment in telecommunications networks, provision of advisory services. A lot of what I do is advising governments on what we call the enabling environment, the legal frameworks, the laws, the regulations that go around the communications infrastructure investment that we do. So that includes things like telecommunications law, privacy law, cybercrime, cybersecurity law, and other aspects of the legal framework that encompass all of those things. So it's interesting the introductory remarks about constitutional law, about freedom of the press. I think those things will resonate with you, I hope, as we go through the presentation. So I'm going to ask your indulgence, please, to take a few leaps of faith with me this afternoon. Because what I'm going to talk about is two intersecting arcs. One is the development over a stretch of time of human rights, international human rights. And the other is the development of the rise of what we now recognize to be nation states in how we structure our international relationships. And to posit this, I'm showing you two pictures. For those of you who might be listening but can't see them, there's a picture, they're two very similar pictures. They're spread apart by a few hundred years. One is a picture of some people negotiating a series of treaties that became known as the Peace of Westphalia, that gave rise to what we now recognize as the nation state, which is the single construct that we use to structure our international relations. The Peace of Westphalia was entered into around 1648, and we're still living with the consequences of that today. What it replaced was a series of fiefdoms and other forms of governance and government that interrelated with each other, in which individuals had certain ways of interacting with those governing bodies that are different than the way we do today. The picture on the right is also a treaty negotiation, that one from last December in Dubai. It was called the WICET, World Conference on International Telecommunications. It was WICET 12. The people in both pictures look about as interested in what they're doing as the others do, don't they? I mean, they all look so bored, it's like, which is too bad because they're doing really important stuff. So during the course of the afternoon, I'm going to attempt to explain to you why these two pictures are related, how they relate, and how they impact our lives today. How many in the room are familiar with the scissors crisis? Okay, the scissors crisis was a term that was coined by Leon Trotsky when he was minister of the new Soviet Union. And the scissors were just a representation of two axes that were intersecting. One of the axes represented agricultural production. One of the axes represented industrial production. The problem with Russia was that the price of agricultural production was such that it could not support feeding the workers who were making the things. So industrial production and agricultural production were going in different ways. Trotsky's problem was how to close the scissors. Okay? It's a crude rhetorical device, but what I'm suggesting here is that we're in the midst of another scissors crisis. We have this arc of the rise of the nation state going in one direction, and in a slightly different direction we have the arc of human rights as we know it today. So some of the things we're going to be talking about today are this difference between the role of sovereign states as they were born out of the Westphalian system versus the emergence of non-state actors in international relations as they concern internet governance. We're going to talk in that context about how human rights evolved to the point today where we believe, and I think we would all believe, that there are certain rights online, rights to privacy, rights to communicate, and how those have arisen and why they're being challenged today. I'd also like to suggest, since this is a law school, what the implications are of these developments for the development of international law today, and I'm going to posit that what we're seeing is the emergence, because we're dealing with non-state actors, the emergence of soft law concepts that govern the internet today and that affect these rights. Throughout the presentation, you'll hear a recurring theme about striking a balance between things. And in the case that we're talking about today, we're really talking about balancing those rights, those human rights, versus balancing things like security. There's a trade-off there somehow. And we know that from our own US Patriot Act, which put into sharp contrast for us, I think, for the first time, the balance of rights versus security, in that case, national security. I'm going to introduce you to a concept called multi-stakeholderism. Say it after me. Multi-stakeholderism. Great. Multi-stakeholderism is, thank you, is the organizing construct around internet governance as we know it today, globally. It's not, I put this up very early in terms of the contrast between that Westphalian state construct, states versus states in terms of doing things in the international sphere, to something that's very different, multi-stakeholderism. It does involve governments, but it also involves NGOs. We heard about NGOs a little bit earlier. It involves the IGOs, the international governmental organizations. But in terms of internet governance, multi-stakeholderism was put in place for a very specific reason. How many people here have heard of ICANN? 2% exactly, okay, great. ICANN is a California not-for-profit corporation which manages, among other things, what we call the domain name system in the internet, the DNS. .org, .com, it manages the country-level domains, so .za for South Africa, for example. ICANN is a creature of the US Department of Commerce. Now, California not-for-profit corporations don't have shareholders. They don't even need to have members. In this case, the governance of ICANN was through what was called a Memorandum of Understanding with the US Department of Commerce. And for years, it ran and functioned fine. In about the early 2000s, the complaints were raised about this system, complaints by other countries. As remember, this California not-for-profit corporation manages all the country domains. And certain governments thought, well, hang on a second. I should be managing my country domain. And I won't get into the merits of that discussion right now, but what it did do is it triggered a debate at a very high level about internet governance. Internet governance was initially all about this question of ICANN and who should manage the domains. Internet governance now has emerged beyond that, or at least I hope to demonstrate that this afternoon, to cover things like human rights now. Human rights issues were not really part of the agenda, the original internet governance agenda, because it was all focused on these technical issues about ICANN and complaints about that. Okay, that's the basic background. Now we're going to walk you through a few things. I'm going to give a brief history about the evolution of human rights on the internet. I'm going to tell you a little bit about what the ITU is and what WICIT is, and I'm going to talk a little bit about how these rights have evolved to the point where we are. And then, after you suffered through all of that, I'm going to give some concluding remarks and my predictions for the future. For those of you who can't see it, because it's not a very clear picture, this is the Déclaration des droits de l'homme, a French Declaration of Human Rights from 1789. It was the first time really that there was a recording of the statement of rights of individuals against the state. Who had the responsibility, who had the rights. A very early statement, around the same time that our Enlightenment philosophers here were doing our Declaration of Independence and our Constitution. It all comes out of the same age. But this was really the first statement. We then had a couple decades, couple centuries of non-development of human rights, but the next big evolutionary mark was this piece of paper that our friend Eleanor Roosevelt is holding, and that is the UN Declaration of Human Rights from 1948. As it emerged from World War II, this was a new statement about an individual's rights and how they would be protected against states. Under the Universal Declaration of Human Rights, there are two covenants: the Covenant on Civil and Political Rights and the Covenant on Economic and Social Rights. Now, all UN members are members of the Universal Declaration of Human Rights. Let's see who the members are of the Covenant on Civil and Political Rights. The dark green countries are those countries who are members, and the light green countries or the gray countries are those who are not members. Now, the Covenant on Civil and Political Rights covers things like privacy, like freedom of expression, that sort of thing. And you can see that there are a couple of outliers there, a couple of obvious outliers. Now let's take a look at the Covenant on Economic and Social Rights. Again, there are a couple of obvious outliers. Interesting, isn't it, when you look at them in contrast with each other? Now, of the outlying states for the Economic and Social Rights Covenant, you might wonder, why is that country in North America not a member? And again, I don't want to get into the merits of it here because it would deserve a lecture in itself, but basically there are provisions in it that the US government objects to in terms of the right to own property or the right to have a job. Those are rights in the Economic and Social Covenant that the US doesn't agree with for whatever reason, and so they're not a member. But let's talk about those civil and political rights. So basically there are two, and I've put them up here. They derive from their original statement in the Covenant, in the Universal Declaration of Human Rights. I'm going to refer to them in the speech today as Article 12 and Article 19. Article 12 is the right to privacy, basically, and it says that a person has a right to privacy in his home, in his or her home, and correspondence. We'll get back to that. Article 19 is the right of freedom of expression. And the right of freedom of expression, and remember, these were written or adopted in 1948, so they're probably written in 46, 47. As memory serves, those were pre-internet days, so they couldn't have been anticipating the internet. But the language was such, I think, that it anticipated and was very flexible. So Article 19 basically says everyone has the right to receive and impart information regardless of medium and across borders. That's a pretty powerful statement. I think as such, it doesn't need any addition, any amendment. I think it applies to the internet today. Those two rights, the Article 12 and the Article 19 rights, were then re-upped, if you will, in the Covenant on Civil and Political Rights, and I've got them here. I'm going to focus on Article 19 because it really gets into more detail about how this right, and it's at the very bottom of the screen, how this right is exercised. It also adds a provision about exceptions to that right. These are not absolute rights. These are rights that are attained in a balance. They're exercised in a balance. And interestingly, the sub-provision 3 of Article 19 does tell us, it provides a roadmap for us of the reasons under which these rights might be accepted. National security is one. When they are accepted, it has to be done in a proportional way. It has to be transparent, et cetera, et cetera. I've separated this one out because this is core to the discussion about how these rights are protected or not protected today in internet governance. And say that recent pronunciations by the United Nations have really brought these very general but very flexible and applicable terms up to the modern age. So there are two reports that have come out within the last 2 years from the United Nations. One was by a special rapporteur named Frank LaRue, who did conclude that indeed these rights are rights online. These fundamental rights are human rights that need to be respected online. Subsequent to that, the UN Human Rights Commission adopted a resolution last summer that also clarified its position that the rights that we enjoy offline, we enjoy online as well. So those rights that began in 1789 with the Declaration of Human Rights have been brought right up to the current time, and they exist. Let's talk a little bit about how in practice this right of communication gets played out in the internet governance sphere. I'm going to talk about an issue called net neutrality. Show of hands, who's heard of net neutrality? You don't count. Okay. Fair enough. Most people haven't. There was a big debate in Washington, and I suppose since we're in the center of the country here, like most debates that occur in Washington, they're resoundingly ignored. And they should be, most of them. Net neutrality was a debate between content providers and content carriers about who is going to bear the cost of carrying content. In the United States, the net neutrality debate was seen as primarily a technical issue, pitting companies like Verizon against companies like Google. And the big issue was, frankly, downloading movies, videos. They clog up the internet. They consume a huge amount of bandwidth. And the Verizons of the world, the people who provide the infrastructure for all this stuff, said, hey, it's not fair to clog up our internet with your content and make us pay for it. You guys should be paying for it. And Google said, no, no, no. Google and others. We're providing a service, an information service, and we're agnostic about what comes over it. So I'm going to suggest that actually net neutrality is more a free speech issue than a technical issue. Now this is again, for those of you who can't see it very well, this is a picture of Speaker's Corner in Hyde Park in London. Speaker's Corner is a place that if you're ever in London on a Sunday morning and are bored or can't sleep because of jet lag, go to the northeast corner of Speaker's Corner and you'll hear some outrageous things. But what's fantastic about it, what's absolutely fantastic about it, is that everyone who wants to can say what they want. This is free speech in practice. It doesn't get any purer than this. You're saying, well, how is free speech related to net neutrality? It's a technical issue. It's, people downloading movies. Well, I have a great deal of sympathy for the movie downloaders of the world who might be affected by this. But I'm going to suggest, and I'm going to provide an example about why net neutrality is really a human rights and free speech issue. The picture on the left is Tahrir Square in Cairo. Kind of looks a little bit like Speaker's Corner. A lot of people standing around, a couple people standing up speaking. In the Arab Spring, that started in Tunisia and then moved on to Egypt and elsewhere, use of the internet, both as a organizing and rallying force, but also as a means of communication, was essential to the political movement. Imagine in this country what would happen to political speech if we couldn't express ourselves using our gadgets. Well, that's what happened in Egypt. All those people in Tahrir Square, for about 48 hours, their internet was shut down by the government. The government figured out that the only way we could stop these Facebook organizers and these Twitter organizers and other users of mobile broadband technology was to shut down the internet. So this technical measure of controlling traffic over the internet had a direct impact and was intended to impact free speech. So I submit to you that net neutrality, this very kind of vague and innocuous term, is actually a human rights issue. So the Council of Europe, which is an organization of European states, which is not the European Union, devised a response to the net neutrality issue. It came out in 2011. And they mixed these two concepts of technical and free speech. And they said traffic management measures, you'll notice they don't anywhere use the term net neutrality in their definition. But they adopted a resolution that said these traffic management measures, to the extent that they're put in place, can be put in place for sure, but that they must meet the requirements to respect human rights, and especially the freedom of expression online. So we have in the international community, at least for 40 countries in Europe, a recognition that these technical issues online do impact human rights and how they do it. Let's talk a little bit about what multi-stakeholderism is. You thought when I mentioned it first that was it and I wasn't going to come back to it? Well, you're wrong. Okay, here we go. Okay, how many people in the room have heard of the ITU, the International Telecommunication Union? Okay. The ITU is a UN organization. It's one of the oldest international organizations in the world. It was founded in 1865, and it was responsible for, it started out as the International Telegraphy Union, and then became Telecommunication Union. And there are some who say that now it would like to be the IIU, the International Internet Union, because it's logically progressed from telegraphy to telephony and now internet. The ITU is in some ways at the core of this debate about internet governance and human rights. The ITU was the specialized UN agency that was charged with something called WSIS, the World Summit on Information Society. Just to make it complicated, there were 2 summits. There was one in 2003 and one in 2005. Out of this process, out of this WSIS process, on the particular issue of internet governance, the following definition of multi-stakeholderism was devised. It was devised as a compromise, a political compromise, because what was really at issue here was what to do with ICANN. Remember, this is 2005. A number of states wanted to say, look, this ICANN function, this domain name function, and the other technical functions that ICANN does is just simply too important to be rested in a California not-for-profit corporation whose only control is the US Department of Commerce. The international community doesn't like it. Well, I think the US government had something to say about that, and they said, hang on. It really isn't that bad. How many times has the internet gone down? 0. At that point, how many countries have been shut out of the internet because of aggressive US behavior? None. So the system works. The system basically works. But we, because we're a benevolent country, we understand your concerns. We'll set up a process. Instead of moving ICANN over to the ITU, or the IIU, we'll set up this process called the Internet Governance Forum, the IGF, and we're going to use as a principle, an organizing principle of this process, something called multi-stakeholderism. And this is an extract from the declaration that was adopted at the end of the summit. I won't go through all the blah, blah, blah. I'll put up my own blah, blah, blah instead, which basically is a distillation of that to show who multi-stakeholders are and what they're doing. It's meant to be a bottoms-up approach, an inclusive approach that involves all the different actors in the provision of internet services. So governments, for sure, because they provide the policies and the laws and regulations that allow it to happen. The private sector, because they own and run most of the internet, provide most of the services. Non-governmental organizations. Now, in this case, ICANN would be considered an NGO. And the IGOs, the international governmental organizations like the World Bank, like the ITU, others, something called civil society. I never really understood what civil society meant because I didn't know what uncivil society was. But civil society are groups of like-minded people who get together and who share common ideas and organize themselves loosely and who have a voice, a formal voice in internet governance. The technical community, this is very important because there's a group called the IETF, the Internet Engineering Task Force, which is not a thing. It's a group of engineers who get together and who devise the protocols, the IP protocols over which the internet works. And something called academia, which I guess includes some of you guys. What this means in terms of internet governance is that there's no single point of control, as opposed to that Westphalian model where there are recognized points of control and you could deal with them back and forth. There's no single point of control. So that's the concept. What does it look like? So let me briefly kind of try and explain a mapping of what multi-stakeholderism looks like. So on the left-hand axis, you've got most international at the top to least international at the bottom. On the horizontal axis, you have very local on the left, no non-governmental on the left to formal governmental on the right. And you'll see that a lot of the actors in here who fit all of those descriptions I made before of states, private sector, NGO, IGO, et cetera, fall somewhere in this map. These are the characters who are involved in internet governance. They're all over the place. There's no single point of contact. You take any one of them out and you might be in trouble. And they all have to act together somehow. So I've been speaking about ICANN. It is a very international thing, so it's high up on the vertical axis, but it's non-governmental, so it's very far left on the horizontal axis. Let's drill down into ICANN a little bit and see how it handles this concept of multi-stakeholderism. This is an organizational chart for ICANN. It also is all over the show. Every imaginable constituent group that you can think of is represented somewhere on this chart. Even the World Bank is part of one of these constituent groups. The GAC, which is on the upper right. Government Advisory Committee was put in place as a direct response to complaints that were raised during the WSIS process about the hegemony of the US government in the management of the internet. The Government Advisory Council consists of Westphalian states who can share their concerns about the management of the domain name system. It also has space for intergovernmental organizations, so the World Bank, the ITU, and a few others are included in the GAC. You can see that multi-stakeholderism is a bit messy and not terribly well organized just by looking at it. Seems like there's probably an easier way to organize this thing called internet governance. Which brings us to the present. So very quickly, I'm going to try to explain a little bit about what happened at the Wicket, why it matters, and what it might mean in terms of the regulation of human rights in the context of internet governance. Every so often, there's a meeting to update a treaty. The treaty is called of the ITU is called the International Telecommunications Regulations, ITRs. The last one prior to 2012 was sometime in the late 80s, I believe, 1988 or something like that, roughly. This is a map of the specialized agencies of the United Nations. And the red circle there is ITU. ITU is under the Economic Council of the United Nations, founded in 1865, well before the UN was founded. And then right up here we have the World Bank. We're under the same organizational kind of structure within the UN. And there are a lot of others, and we don't need to talk about them. I just wanted to show you where it fit in with the UN. So the ITRs that came out do say that, you know, these are going to be binding on states, these regulations are binding on states, therefore it's a treaty, and that the states will abide by human rights. This is an extract from the preamble. So far, so good. That's all okay. And most of the rest of the ITRs that were adopted were very technical in nature and cause me to blur my eyes when I look at them too much. It's all about radio spectrum planning and frequency management and stuff like that. Really technical stuff that's important, and I'm glad some people do it, but not me. The problem arose when there was attached to it a resolution. There are a number of resolutions attached to the ITRs. And no one really knows, from an international law, public international law perspective, what these resolutions mean. Because they're supposed to be non-binding, but they're attached to this treaty, and no one really knows what that means. Now, the resolution that was attached to the ITR at the Wicket was this one. This is the one that caused everybody the heartburn. And if you look at it, it doesn't really sound that awful. It says basically government should have an equal role for international internet governance and ensuring the stability and security of the internet. Well, that all sounds pretty good, doesn't it? And it goes on to say that the member states will look at all these issues and that the ITU will manage the process. I mean, none of that sounds horrible. Now, I need to back up and say that this resolution was originally tabled by the Russian delegation. It was rejected during the course of the negotiations, was taken off the table, and then when certain delegations left the room, the chairman of the Wicket said, I want to test, literally said, I want to test the temperature of the room on this resolution. And so everyone said, yeah, we're for it. I said, okay, well, we'll put it on. This was on the day before the conference concluded. There was no time to have any other discussion about it. It was very late at night. So this resolution was attached. Now, It bears a striking resemblance to a previous attempt by certain governments, Russia, Tajikistan, Uzbekistan, and China, in the context of the UN General Assembly to push through this state-centric process of internet governance, wresting control from all those multi-stakeholders who are involved in managing the internet. And in that resolution, which failed, was not adopted, the Russians and their friends said, well, in curbing dissemination of, they wanted to curb dissemination of secessionist communications. That sounds a bit like censorship and a restriction on freedom of speech. And to promote, among other things, the equitable distribution of resources and to preserve the role of the state in internet management. Well, you can see what they were trying to do. They failed in the General Assembly, so basically they took their product and tried it again at Wicket. They got a lot further with Wicket because it was adopted, not by all states, but by the states in green. It's very hard to see that, but roughly 89 of the 160 or so countries who were part of the previous treaty, so about 2/3, adopted the ITRs with this resolution attached. Now you'll notice that of the countries that did not adopt it, those are the countries, with one exception, those are the countries where the internet is. Those are the countries where the root servers are. Those are the countries that are the vendors for the equipment. Those are the countries that provide the services and operate the networks. All those guys said, ugh, we don't like it. We're not signing up for it. Now the exception is China, because China, as we know, is an important and growing producer of telecommunications and broadband equipment. They have operators all over the world. They're selling their stuff all over the world. So what I think we're seeing here is the rise of two competing sets of technologies around the internet. What does it mean, though, from a public international law perspective? I don't know. You had a treaty in place. You had a new treaty that was supposed to take its place that 2/3 of the members signed up to, and an important 1/3 failed to agree to. So I think one of the things that we're facing is a kind of a WTO Doha continuing in perpetuity round of discussions on this issue. It cannot be that the countries that own and control the internet are not part of the treaty. It's a nonsense. It just doesn't make sense. So that's one implication. What does it mean in terms of the rest of the ITRs? Does it mean that countries who were members of the previous treaty use that treaty? Do they ignore the new treaty? Do they operate amongst themselves on the basis of some sort of customary international law in the absence of a treaty? I really don't know the answers to all these questions. But it poses some difficulties for us. To make matters worse, all of this consternation about developing a treaty to govern the internet, with the US leading the debate, has kind of come back and bitten because of something called Stuxnet. Okay, last time I'm going to do this. Who's heard of Stuxnet? Good. More of you have heard of that. Okay. Stuxnet was for those of you who hadn't heard about it, was a bit of malware that was used in a denial of service attack or some similar attack against facilities in Iran. It emerged that Stuxnet, this is what I read in the press, I don't know if it's true or not, it emerged that Stuxnet was actually an initiative by the US and the Israeli governments. So we have, on the one hand, general internet governance regarding these rights, and the US government saying, no, 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 we cannot have a treaty, we cannot revert to this state-by-state management, it's a multi-stakeholder process. And then we have Stuxnet come along, which plays into the hands of those same people who want a state-by-state control, because they're saying, hey, wait a minute, you guys are using what we would ordinarily call cyber security, cyber crime stuff in the civil context. You're using those same issues that we fend off at home with antivirus software, and you're turning it into cyber war. we have got to have a cyber war treaty. So at the same time that you can see the predicament that the US government is in, on the one hand, arguing against a treaty in one context, and then backing themselves into a corner to have to discuss a treaty about international governance of the internet on the other. It's a very complicated situation. So let's look at the third largest country by population and how they handle these issues, especially privacy. Does anyone know where I'm going with this? Facebook's got about 1 billion users worldwide. After China and India, they'd be the third biggest country. This is the law of privacy and freedom of speech in this country. Did you have anything to do with it? Do you like it? Do you use it? I don't know. This is what we're stuck with. This is what I mean by soft law, playing a role in the management of international human rights on the internet. I won't even put Google up there, but a similar sort of thing. Actually, I lied, I will. Everyone read the Google Terms of Service? Were you that bored? This is the reality we live with. We have states trying to take over the management of internet governance. We've got private sector entities who are forcing us to behave a certain way online. We've got various and competing things happening in the world that affect our fundamental rights. So where do we go? Well, I think we're stuck with multi-stakeholderism. I don't think that's going away. The interests are too entrenched. They're too serious. Human rights is a feature of internet governance. That's not going away either. The role of states and non-state actors has to be accommodated somehow. And finally, from the point of view of public international law, I really don't know where any of this is going. But it'll be interesting in the next couple of years, so thank you very much.
I think we have time for a couple of questions.
I could throw some more acronyms at you, and we could start it that way.
This was sprung on me, so I didn't have a chance to test the equipment. Anybody have any questions? Well, I have one.
Shoot.
My family and I were in Nepal when the royal family was massacred, and they shut down the internet. And ever since then, I wondered, how does a country, I thought, well, maybe there's a plug somewhere in the palace.
Master switch, yep.
Yeah. How do you shut down the internet in a country and just in that country?
From a legal perspective or from a,
From a
technical perspective? Okay.
People
So,
want to do it.
yeah. If the Creighton website goes down, you'll know who did it. Okay. So, I don't know what happened in Nepal, but I do know what happened in Egypt, because we were working with the then Minister of Communication, who left and is now a senior policy advisor at an organization called ISOC, the Internet Society. Go figure. So it's complicated, but kind of understandable in terms of the national network and the international network. So what they did in Egypt, as I understand it, was that the Egyptian sites using .eg, I think is the two-letter country domain for Egypt, were in the control of the government through a cascade of power that went from the president to the Minister of Interior and Minister of Communications. Telecom Egypt was, still is I think, the domain manager of .eg. So there was an instruction given at some point to take that off. Now there are different ways that you can do that. I mean, the easy physical way is, I mean, on the Excel spreadsheet where the thing, you just delete that line and it doesn't register, it can't resolve. I don't think there was a switch that they pulled in Telecom Egypt, but Telecom Egypt was the one that shut down the national internet. So the internet globally was never shut down for Egypt. You could still reach it through other domains, .coms and stuff like that. It was just harder. And what Telecom Egypt could also do was shut down the physical connectivity, the pipes and wires that connected the national infrastructure internationally. That's easy enough to control. In Nepal, I don't know what happened, but there are various ways of doing it. I think they realized that it was futile at that point. It only lasted about 48 hours.
I assume it was a state-run telco at that point, because otherwise, for the U.S., where you have basically private telcos that are communication companies, you'd have to get the Verizons or AT&Ts or the AT&Ts to shut those down here.
So the question was, in case you couldn't hear it, was assume that in those countries, Nepal, Egypt, and others, that there were state-owned enterprises, state-owned telcos who could pull the plug and shut it down. Yeah, the answer is yes. And that it would be more difficult in places like the United States, where the internet is owned and run by private sector entities like Verizon and others. Yes, although there is, I don't know if it's an executive order or if it's legislation that gives the president the power to effectively order those companies to do the same thing. But there is no ability of government to go in and open a box and pull plugs.
Ed has a question.
I would say that where we do have the internet, we see all kinds of examples of government censorship. For example, in China, shutting off access to the New York Times, etc. Do you think it's going to be technologically feasible for government to selectively govern the internet, given the tools that people have to circumvent those blocks?
Everyone hear the question? Part of the problem that I'm trying to point out here is that, yes, under the current protocols that we have in place, I mean, it's designed to be a redundant network, that if there's a problem here, you skirt around it, and you still get to where you want to go. That's the beauty of it. The problem that could arise is that if there is a country that has a big enough market, that has manufacturing capability, that has technological know-how, and is clever enough to develop an alternative protocol, which isn't as redundant, which is more vertically controlled and static, then it would be a lot easier, I think. And that, to me, is the real danger of the sort of situation where we are here. Look, the middle-class market in China is the size of the whole population of the United States. That's a big market. China is exporting goods and services all over the world. They're buying natural resources in exchange. If they're successful in promoting an alternative set of protocols for an alternative net, then I think you could have that situation. And then, from the legal point of view, what we have developing is a series of attempts to put all that control back in the hands of the state and take it away from those other entry points that can control and complain about it. I mean, currently, I don't see it, but I think there's a possibility for it. Yep.
What is the World Bank's role in attempting to influence these organizations?
Thank you. Excellent question. So the bank's interest in this area, apart from the fact that we're just concerned, obviously, is that we provide financing and funding for deployment of infrastructure. So I'm working in 20 or so countries at the moment where we're trying to introduce broadband connectivity, whether through submarine cables or terrestrial fiber or something like that. So we're bringing in these big pipes, and there's a lot of capacity flowing in and out of the countries. My view is, and so far I've been successful in convincing my institution of it, is that along with that, we need to provide an enabling environment that provides certain safeguards and guarantees around things like privacy of the individual and protection of their rights of free speech, which are human rights that are determined by organizations other than mine. They exist, they're out there, I cannot deny them. And to prevent creating havens for cybercrime. So we do think that we have a fiduciary role, a fiduciary responsibility to our clients, that when they say, hey, we'd like to build out more capacity for the internet, we say, yeah, okay, but you also need to think about these things. And part of our financing will go towards the technical assistance to look at that. So the way that the bank operates primarily is on a bilateral basis with our members. The World Bank is like an agricultural cooperative bank. To borrow from it, you have to be a member of it. So while we do interact with the other organizations, which I think was your question, our real influence is bilaterally with our borrowers. And we were talking at lunch today, the bank is a sovereign, and so when we deal with a state, a Westphalian state, which is also a sovereign, so I'm not dissing the Westphalian concept overall, okay? I'm just saying. When it's a sovereign-to-sovereign engagement, which is a treaty. And so the World Bank lending instrument is a very powerful instrument, because it usually, in every legal system that I know of, treaties trump the law of the land. They're a superior legal instrument. So it's a very powerful instrument that we have. In my view, we don't use the leverage enough when we should in areas like this, but it's there. All right, thank you very much.